The IRS gave groups like Media Matters a pass, but they're going along after these guys, the Tea Party patriots. Judge Andrew Napolitano, Fox News senior judicial analyst, joins us right now to weigh in. Judge, it's been revealed that apparently the IRS has been targeting conservative groups because they had things in their name like Tea Party and patriots and things like that.
This is really profoundly wrong under the Constitution and under federal law. And as former Vice President Cheney said last night, it's hard to imagine that something of this magnitude was concocted by some low-level, entry-level IRS employees.
And now we know that in fact, the boss there knew about it a year ago.
Right. Here's the violation. The Constitution says the government has to follow the equal protection principle, which means it must treat similarly situated entities in a similar way. So if it's going to scrutinize, I'll just give you an example, Americans for Prosperity very aggressively, it has to scrutinize Media Matters very aggressively. It would have to scrutinize all entities in that same category with the same level of scrutiny. The First Amendment is also violated because the First Amendment prohibits the government from making decisions based on the content of speech. And it is clear here that the government, the IRS, has decided to upgrade the level of scrutiny of certain groups applying for tax exemptions based upon their message, based upon the content of their speech. And the First Amendment was written to prevent the government from doing that.
Absolutely. So what it looks like is they went after right-wingers and they exempted left-wingers, and that's your problem.
Correct. Now, look, if there's a problem with somebody's application, they didn't put in the name of everybody who made contributions.
Yeah, but they were asking for family members. They were asking for donors, and give us speeches that people are giving.
If there's a problem with an application, they can look into it. But to demand more information from one set of applicants because you disagree with their message than you demand from others who are seeking a similar or identical exemption is absolutely prohibited. But guess what?
What?
Congress doesn't allow the IRS agents who did this to be prosecuted or to be sued, and it doesn't allow the IRS to be sued. The only remedy is political. Kick them and their bosses out of office.
Oh, man.
So there's a lot of laws that have to be changed, Steve, to prevent this from happening again.
All right. Judge Napolitano, thank you very much.
Pleasure.
It's troubling.
Now, I'm not familiar with all that went into the formulation of the subpoena. I was recused from that matter, but I'm confident that the people who are involved in this investigation, who I know for a great many years, and who I've worked with for a great many years, followed all of the appropriate Justice Department regulations and did things according to DOJ rules.
Judge Andrew Napolitano is our Fox News senior judicial analyst. Your take on it, Judge?
Well, he has a lot of questions to answer. He shouldn't have been giving the press conference because he recused himself from the case and he wasn't able to answer the poignant questions.
Well, it was on another matter, and you got questioned about this, of course,
right
at the end.
Right. It just happened to follow Jay Carney's press conference in which he couldn't talk about the AP story. Look, the AP story, the government seizing phone records, cell records, home telephone records of reporters is a profound and direct assault on the First Amendment. This administration, like everybody who works for the government, like you and I when we became lawyers, took an oath to uphold the Constitution, which includes the First Amendment. There's only three ways they can get these records. They can have a grand jury subpoena them, in which case the subpoenaing entity, the U.S. attorney who presents the case to the grand jury, has to tell the person, we are going for your records. They're not in your custody.
Hello, AP?
Correct.
We're going to go get your phone records.
These records are in the custody of Verizon or whoever it may be, so we're not worried about you destroying them, but you have a right to challenge the subpoena.
They didn't do it.
Correct. Or they can go to a judge, present evidence of probable cause of crime, and get a search warrant, in which case they don't have to tell the AP. They just show up at Verizon's office or whoever the carrier is and get the phone records.
There's an exception, though, to having to tell them when national security would be at risk at telling them.
Yes.
They claim that this was the case. Even though the AP was reporting on something that had happened months and months and months earlier, they claimed if they told the AP they were doing this, national security would be at risk.
Here's why they can't have it both ways, because the third way that they can get these records is a national security letter. Basically, a federal agent writes a search warrant authorizing another federal agent to get the documents under the Patriot Act. In my view, and in view of many who observe this, and at least 6 federal judges, this is unconstitutional, but it is the law. When they do that, They have to certify that it is a matter of national security and they are investigating terrorism. They already told us this is a plain, old-fashioned crime of leaking.
We got 30 seconds of the hard break, and we're doing the IRS story with Jay Sekulow and a targeted person next. I want to get to that, so quickly. Overbroad, cast too wide a net. Even if they could do it, was it done improperly?
It was absolutely done improperly. They didn't follow any one of the three ways that they could do it under the law. They violated the most core protected rights under the Constitution, freedom of speech.
Unbelievable. We had the president mocking people who are afraid of tyranny in this country recently.
Mr. Holder, you appointed special counsel to investigate Benghazi?
No.
Well, that's Attorney General Eric Holder flatly rejecting the idea of appointing special counsel to investigate the Benghazi situation. So we have to trust the government on that one. Well, the government also says the IRS scandal was handled by firing somebody who already planned on leaving and frankly didn't make any of the decisions about attacking the Tea Party. And when grilled on Capitol Hill, Holder stuck by the Justice Department's seizure of AP phone records, saying he'll handle that as well. But can we really trust these officials to handle investigations on their own? Here to weigh in is Fox News senior judicial analyst Judge Andrew Napolitano. All right, so that's a handful of stuff I'm throwing out at you, Judge.
This has not been a good week for the government. The common thread here is that the government can't be trusted, but the government thinks that we will trust them. The government will break whatever law it wants in order to meet its own political ends. The government doesn't feel confined by the Constitution it is sworn to uphold or the laws that the Congress has written to protect our liberties.
All right, so what did the Justice Department do wrong with regard to the AP story?
There's only three ways that they can get phone records. One is an old-fashioned traditional search warrant from a judge in which you present evidence of a crime and the judge decides whether or not to issue a search warrant. They didn't do that. The second is a subpoena from a grand jury. We are investigating this crime, the leak of confidential and classified information, and the grand jury is interested in seeing your records. When they do that, they have to tell the person whose records they are attempting to subpoena that they are doing so that the person can challenge the subpoena in court. They didn't do that. The third way is for an FBI agent to authorize another FBI agent, an agent-written search warrant, to seize records under the Patriot Act. That can only be done when the pursuit of the records is in order to find a terrorist. So they haven't told us which one they did. I suspect they either used a grand jury subpoena and did not tell the AP they were doing it, which violates the federal rules of criminal procedure, or they used an agent-written search warrant called a national security letter, even though this was about a crime, leaking classified information. It was not about the behavior of a terrorist who was on the loose that they're trying to find.
So does this cry out for an independent investigator to look into this?
Well, it sure does, because this is the government breaking its own laws. These are the people we entrust to enforce the law, to protect our liberties, to protect our safety, and to protect our property. Okay. They broke the laws they're supposed to enforce.
Real quickly, how is that different? How is an independent counsel different from an inspector general?
An independent counsel does not have to answer to the attorney general. An independent counsel has his or her own budget. His or her own FBI agents can summon his or her own grand jury and seek his own indictments. An inspector general only reports. He doesn't prosecute.
All right, let's take a look back at history of some other independent counsels. President and Hillary Clinton, illegal solicitation of Whitewater loans.
Who can forget that one?
1994. And then Henry Cisneros, Secretary of Housing and Urban Development, false statements to FBI, 1995. President Clinton, Monica Lewinsky scandal, 1998. Alexis Herman, Labor Secretary, illegal solicitation of campaign funds, 1998. And Louis Scooter Libby, leaks involving CIA operative ID, 2003. So in those cases, it was an independent counsel. What heights did those cases have to come to in order for it to be investigated in such a way?
Well, the independent counsels in those cases came about under a statute that authorized courts to appoint independent counsels. At the present time, the only authority that can trigger an independent counsel, drum roll, Eric Holder, the Attorney General of the United States.
Well, we already heard from him. He's not going to do it.
Right. He would basically have to agree to appoint an independent counsel to investigate his deputy, his number two person. What did we hear him say all day yesterday? Congressman, I don't know the answer to that question. I wasn't involved in this case. Well, where is the guy that was involved? He should have been seated next to you.
Yes or no? Did Eric Holder do that on purpose to not be involved in this?
I don't know what went through his mind, but he was the wrong person to be answering questions. Tom Cole, his deputy, who apparently authorized the invasion of privacy on the Associated Press, is the one who should have been on the hot seat yesterday, because he surely knows what he did and why he did it.
All right. Great to have you on this topic because you are the expert, Judge, and thanks for the quick trip back from D.C.
Of course.
Thank you.
Again, breaking news that has come in recently. Fox News has now confirmed President Obama will name a White House budget official as acting IRS commissioner. His name is Daniel Werfel. He worked in the administration for years, dealt with budget issues. He will replace the outgoing IRS boss. Now, the president didn't directly answer a question today about when people at the White House knew about this IRS controversy. Remember what the question is. In fact, this is the exact question as read by Megan. Megan, thank you. This is the question from a Bloomberg reporter at the news conference a short time ago. Can you, Mr. President, assure the American people that nobody in the White House knew about the agency's actions before your counsel's office found out on April the 22nd? The agency, she was referring to the IRS. It was absolutely crystal clear. One more time. Can you assure the American people that nobody in the White House knew about the agency's actions before your counsel's office found out on April 22nd? Roll it.
Let me make sure that I answer a specific question. I can assure you that I certainly did not know anything about the IG report before the IG report had been leaked through press, through the press. Typically, the IG reports are not supposed to be widely distributed or shared. They tend to be, a process that everybody's trying to protect the integrity of.
He said, let me make sure I answer your specific question, and then he went on to absolutely not answer the specific question. Why? Here was the question again. Can you assure the American people that nobody in this White House knew about the agency's actions before your counsel found out on April 22nd? The allegation is that the IRS was targeting conservative groups. The IRS has admitted as much, every bit of it. And the question is, did the White House know? Because the follow-up question, if the White House did know, did you direct any of it? That's the next question. So when the question was asked, can you assure the American people that nobody in the White House knew about the agency's actions before your counsel's office found out on April 22nd, he said...
Let me make sure that I answer a specific question. I can assure you that I certainly did not know anything about the IG report before the IG
that wasn't the question. Nobody said anything about the IG report. No, this wasn't about the Inspector General's report. This was a very simple question. Did anybody, not you, did anybody in the White House know that the IRS was targeting anybody, in this case conservative groups? That was the question. Then he said, let me specifically answer the question, and then he specifically did not answer the question. Judge Napolitano is here, along with Mike Santoli as well. But Judge, as Megan pointed out in the last hour, this isn't a court of law. But if that question were asked in a courtroom and that answer were given,
the person who asked it would ask that the answer be struck because it wasn't responsive to the question. And a judge, not just me, any judge in any courtroom would say, answer the question. This is a Clinton-esque answer. This is an effort to answer a different question, knowing there couldn't be a follow-up because this is not a courtroom and they limited the questions at this presser, and hoping that this would go away.
It's not going away.
In fact, he's made it worse with this answer.
Mike, if the White House knew, we're in new territory.
If the White House knew about the activity, not just the details of the IG report.
Oh, see, that wasn't the question. The question was, did you know about the agency's activities?
Probably is a new territory. And I also think that this entire kind of mode of now we're figuring out, we're parsing exactly who knew what when, shows you why this thing is not going to be dispensed with the resignation of an interim IRS chief, right? So this is going to flower on from here. We have to have a full airing of exactly what happened.
Jay Carney got the same thing. Listen to what Jay Carney said. Not today, before. Listen.
That nobody at the White House and nobody on the president's political team had any knowledge or was involved in any way in the targeting of Tea Party groups by the IRS?
Yes.
Absolutely not.
I mean, look, we found out about this.
See, now that was the answer Tuesday from Jay Carney, but today they asked Jay Carney's boss, the President of the United States, can you assure the American people that nobody in the White House knew about the agency's actions before your counsel's office found out on April the 22nd? Roll it.
Let me make sure that I answer a specific question. I can assure you that I certainly did not know anything about the IG report before the IG.
Okay, I think we've made the point now.
Yes.
If Jay Carney was right on Tuesday, and the answer is we didn't know, we need to hear that, because that's a big deal. And we need the answer from the man in charge of the nation to be responsive. That's only fair. Because if they knew, the next question is, did you direct this? The question would be, are you orchestrating a campaign against political enemies from inside the White House?
In order to undo the effects of a Supreme Court decision that you have publicly condemned and that they have availed themselves of.
No one is suggesting that that's what happened. Because if the answer from the president is no, we didn't know, there is no follow-up question. It's over. That's it. Answered, no, you didn't. We'll keep checking to make sure that's accurate. But that's the end of the questioning. And if the answer is yes, there's another question. So we need the first answer.
We need an environment in which somebody, like you just did, Shep, can follow up with questions rather than this one question and then we move on to another question in a foreign language to a foreign leader.
To me, this isn't about conservative groups being targeted. That's not what this is about. This is about the government going after a citizen wrongly.
Because of the citizen's speech, political speech, the highest protected speech we have.
That's all this is. Partisans want to make this about Republicans and Democrats and left and right. And that's not what this is. This is about the government and the people. The government can't do this. The Constitution says no. The Supreme Court ruling on Citizens United changed the country and not in a good way. But it's the law of the land.
And he hasn't taken an oath to uphold the law of the land, whether he agrees with it or not.
There's a way of, obviously, if in fact it's an excess of care being taken by saying, who knows if anybody in the White House somewhere along the way picked up a stray thought about what was going on there.
Well,
if that's what's going on, then no big deal.
But Jay Carney,
Jay
Carney was specific. Go on.
Sure. No. And if the IG report is the shorthand for, well, when all this stuff was gathered together and put in front of us in one place, that's when we knew the extent of it. On the other hand, there's a way to write this story that says you had this huge flood of one-time new wannabe tax-exempt organizations. We needed a shortcut to get at them. Nobody said that either, right? Everyone's saying the right thing. You cannot do this. You cannot target people, based on keywords or anything else.
The president's a very smart guy.
Yeah.
The president parsed his words because he doesn't want to be accused of lying. Now he's being accused of hiding the truth.
We've reached out to the White House for a clarification. We eagerly await that clarification, and the moment we get it, we will report it. Stay tuned. Heather Hanson's here. She's a criminal defense attorney. Fox News senior judicial analyst Judge Andrew Napolitano is back with us again. Well, the liar and murderer told Fox 10 Arizona that she'd prefer to be put to death. Couldn't she have said to her attorney, don't defend me on this matter. I want to fry.
Absolutely. She could have said we don't want to put on any evidence with regard to the mitigation phase, and the lawyers would have had to honor her wishes. You would have still heard those victim statements because they have the right to put them forward, but you wouldn't have heard from Jody.
And the Supreme Court requires the state to prove this aggravation phase, that the aggravating factors, the bad things about the events in the case, outweigh the mitigating factors, any redeeming value she may have. So even if she remains silent and her lawyers remain silent, the government still has to prove this in order for the death penalty to be imposed. If the government fails to prove it, then the death penalty cannot be imposed, even if those aggravating factors are there.
Well, I can't imagine them killing somebody who's a good friend and an accomplished artist.
Then those are the mitigating factors that she's raised. Yeah. They've hired a mitigation specialist who comes in to try to weave a story in such a way that it's best presented to the jury. So, that may
Which is common.
Absolutely common. And it's probably, as you've already said, part of the reason that the attorneys wanted to withdraw, because she's just putting herself in the way of everything that they try to do to defend her.
Now, if she does not take the witness stand, then that tape of our colleagues at Fox 5 in Phoenix will or Fox 10, excuse me, for all five.
Yeah, right.
Will not be aired for the jury. Though the jury is not sequestered and they probably know of it, the judge would say, hey, if you heard about this thing, just don't consider it when you decide the penalty phase of this case. If she does take the stand and begs for her life, and they run that tape when cross-examining her, you'll see some of the highest drama that we have seen.
I can't imagine them not doing that.
Yes.
I mean, if she says, don't kill me, Roll the tape. It's a Fox 10 Arizona morning, and it's coming right down your throats.
You can't say that. They're going to have to put on some psychiatric experts who say that she's got this borderline personality disorder or something like that, because there's no way that she can say that now and lose even more credibility with this jury. It can't happen.
I don't see anything going well for her. I wonder if she's realizing she made some bad decisions.
She may not realize it. The statement she gave to the Fox Phoenix was not the statement of a lucid person at all.
No. All right, guys, thank you. As all of that develops, we'll take you there. So let's take this to the judge. Fox News senior judicial analyst, Judge Andrew Napolitano. Judge, hello.
Shep.
This isn't about us. It just so happens that this time it's one of our reporters. Last time it was Associated Press. We'll see who it is next time.
Correct.
If James Rosen did every single thing that the Department of Justice listed in the subpoena, where's the crime?
There is simply no crime. And it was terribly wrong for the FBI to tell a federal judge. The FBI submitted a half-page thick affidavit. Here's a copy of it to a federal judge, which is the way you do it. You summarize the reason for which you want a search warrant. And then you say, here's why this person behaved criminally, and here's the evidence the search warrant will uncover. For the FBI to tell a federal judge that James committed a crime by receiving classified information and offering to publish it, even by asking for classified information, is absolutely wrong and brings the Justice Department into an entirely new area of invasion of First Amendment privileges. James, like all of us who are professionals in this business, have an absolute constitutionally protected right to seek news of material interest to the public wherever that news may be. Now, don't get me wrong. It is a crime for someone who has a classified clearance and classified materials in their hands to give it to someone who lacks that classified clearance. It is not a crime if the person who receives it is a journalist. It is not a crime for the journalist to receive it. It is not a crime for the journalist to ask for it. It is not a crime for the journalist to publish it. And it is just terribly wrong to tell a federal judge that that journalist engaged in criminal activity when we know from Supreme Court opinions from the Pentagon Papers to the present, James's activity is absolutely protected by the First Amendment.
And when they do issue this sort of subpoena, by law, they have to tell you they've done it, don't they?
Yes.
I mean, they went into our computer servers at Fox News, went around our security, pulled things out, and didn't tell us they'd done so.
And Fox found out about it, and James found out about it from a report in the Washington Post this morning. Shep, this happened 2 years ago. This is dated May 28th, 2010. The government has an obligation to report this to the target, James, and to anybody else involved, Fox, the computer server, whoever else might be involved, within a reasonable period of time. In fact, depending upon what statute the government relied on, when the information is in the hands of a third party, like a computer server, they have an obligation to tell you beforehand so you can challenge this. They didn't tell anybody.
I read the word chilling a lot today. It's in the statement that's put out by one of our executives. That's actually a word from the Supreme Court.
Yes, it is. The Supreme Court has ruled that when the government makes it difficult for you to do your job as a journalist by scaring off your sources or watching your every move, that's called chilling. Chilling is a constitutional phrase meaning the government hasn't directly silenced me, but it's made it more difficult for me to speak.
Judge, thanks. Hang on a moment. The IRS controversy now as new details emerge over who knew about the agents targeting conservative groups for extra scrutiny before the election in 2012. We've now obtained a letter which the IRS watchdog sent in July of last year to the chairman of the House Oversight Committee, the California Republican Darrell Issa. That letter essentially gave Chairman Issa a heads up that an investigation was underway into how the IRS conducted oversight into organizations requesting tax-exempt status. Now remember, the White House also revealed that its top attorney knew several weeks ago that the investigation was nearly complete. The White House stressed that President Obama did not know about this controversy until very recently, but some top Republicans are arguing maybe the president should have known.
For me to believe that the IRS commissioner knew about this a year ago and didn't tell anybody, it's hard for me to believe that the White House counsel knew about this a month ago and didn't tell the chief of staff. If that's the case, you don't have much of a counsel.
It is critically important that the American people have trust that the IRS, which is is involved, has a very intimate relationship with people and their finances, it's critical that they know that it's being done in a nonpartisan way. And so this was a breach of the trust, regardless of the motivation, regardless of how it happened, it was a breach of the trust, so we have to fix it.
Well, it appears that President Obama's second-term agenda has run into even more roadblocks. Mike Emanuel's on Capitol Hill. Mike, and the White House just revealed more. What do we learn now?
Well, Shep, at the start of a busy week here on Capitol Hill, the White House is fleshing out the timeline about what was known when about IRS targeting.
We knew the subject of the investigation, and we knew the nature of some of the potential findings, but we did not have a copy of the draft report. We did not know the details, the scope, or the motivation surrounding the misconduct, and we did not know who was responsible.
Carney went on to say at that point the report was not final and was subject to change. Now, as soon as tomorrow, there will be more congressional hearings about the IRS matter. In the Senate Finance Committee, they will feature 3 key figures: outgoing acting IRS Commissioner Steve Miller, Inspector General J. Russell George, who did the report on the IRS targeting, and Douglas Shulman, former IRS Commissioner. So you can expect plenty more tough questions tomorrow, Shep.
What can we expect from these next hearings this week on the IRS?
Well, Darrell Issa, the chairman of the House Oversight Committee, who is chairing a hearing himself on Wednesday up here, had this to say, quote, exactly who in the administration knew about the IRS targeting is one of the key outstanding questions. In waiting so long to address wrongdoing and inform the public, President Obama and his administration seem more preoccupied with having deniability than quickly addressing serious wrongdoing. Meanwhile, a leading Senate Republican is calling on his colleagues to have patience.
It's hard to do when you're outraged, but the right thing to do here is let the facts come out. Don't try to prejudge what they are. It's more and more obvious to me that we're going to find out that more people knew about the IRS than have admitted so far they knew about it, and people are going to be upset when that happens.
With the IRS, Benghazi, and the Department of Justice targeting reporters, these controversies threaten President Obama's second-term agenda, even though his aides say they're going to try to move forward with what they had planned. Shep?
Back to the judge. Mike, thanks. Fox News senior judicial analyst Judge Andrew Napolitano. They didn't know anything. The reason this matters, obviously, is because if they knew, the question would be, well, did you direct any of this? If so, were you working on politics from inside the White House? You can't do that.
Well, exactly. I mean, the allegations now are that the IRS was doing this for more than a year. What was happening a year ago? The president was running for re-election. So did people in the White House know that the IRS was applying additional scrutiny to the tax documents of conservative groups, perhaps to keep them at bay during the election? If that's the case, you could argue this was a political decision. If none of the political people in the White House knew about it, then the IRS will say, well, we did this because it was overload. We're getting too many of these applications. You can make both arguments. But the Congress needs to get to the bottom of it, because who knew what when is of paramount importance.
Investigating 501c4s makes sense, because what they do is they have to spend half or a little bit more than half of all of their money on certain matters, and then the rest of it they can just spend on political operative business. That's because of this ruling from the Supreme Court. Whether you like that or not doesn't really matter. But you have to investigate whether they're at the right threshold, whether they're dodging tax laws. That makes sense. But to apply to one side and not apply to the other, that doesn't make sense.
That's the constitutional issue. When the government makes a decision about how to treat a taxpayer based on the taxpayer's speech and political views, same as what we talked about before, that chills the speech. That punishes you because of your speech. It treats people in a similar situation differently rather than similarly, as the Equal Protection Clause of the Constitution and the First Amendment require. So again, this is just the beginning of what needs to be known here in order to resolve this.
Judge Napolitano, thank you.
You're welcome.
A news story now, 14 minutes before the top of the hour. You got a new twist in the government's probe of U.S. journalists. The DOJ not just targeting the Associated Press, which we learned last week, also Fox News in the crosshairs, specifically James Rosen. And let's take a look at our First Amendment and what it means. Fox News' Judge Andrew Napolitano is here. Judge, James Rosen in the crosshairs about his relationship and interaction in 2009 with a State Department source.
James Rosen, aside from being our colleague and friend, is a first-rate reporter whose job it is to cover the State Department for Fox News. As part of that job, he cultivates, like we all do, relationships with people, in this case the State Department, and he talks to them. The Justice Department told a federal judge that by James's talking and flattering a particular
Preying
person
on his vanity,
a particular person in the State Department, James committed a crime. And the allegation was the crime was he asked this guy to give him national security secrets. A, the guy didn't give him any national security secrets. B, it is not a crime for a reporter to ask for this. It's not a crime for a reporter to receive it. It's not a crime for a reporter to possess it. It's not a crime for a reporter to publish it. And the Justice Department knows that. The FBI affidavit, which was given to a federal magistrate judge and which was sufficient to persuade the magistrate judge to sign a search warrant, which enabled the FBI to get copies of James's emails and texting from his personal,
without him knowing it,
without him knowing about it, without Fox knowing about it. That affidavit was so inaccurate. It said that James committed a crime by doing something that it is only a crime for government employees to do, and James is not a government employee.
Well, look at this. The FBI says he engaged in criminal activity. According to Reginald Reyes of the FBI, at the very least, he aided and abetted this guy, Jin-Woo Kim, about a story about North Korea and what we would do in response to their missile launch.
Mr. Kim was indicted not for giving classified material or national security secrets to James or anybody else. There's a picture of him. Mr. Kim was indicted for talking to James. It's part of Kim's job to talk to James and James's job to talk to Kim. This is the first time that the federal government has moved to this level of taking ordinary, reasonable, traditional, lawful reporter skills and claiming they constitute criminal behavior.
And Jay Carney was blistered yesterday by the rest of the press. I guess they thought if they could attack Fox News, you'll be okay, but it looks like they're rallying to his side.
Brian, I
don't know how Jay Carney sleeps at night because he came from the reporting world.
Exactly. Brian, I like that tie.
How dare you prey on my vanity?
I like your face. Now, I'm preying on your vanity and I'm flattering you.
Ted, press charges against him by the power vested in you. Ted's on camera, too. He also watches FBI shows,
you know
so
what?
he's powered.
Rosen is a terrific guy. I don't think he's losing any sleep over this.
Well, if you say he shouldn't, then he shouldn't. Judge Napolitano, thanks so much.
Of course.
Does this woman have a lot to learn her? Listen.
I have not done anything wrong. I have not broken any laws. I have not violated any IRS rules or regulations. And while I would very much like to answer the committee's questions today, I've been advised by my counsel to assert my constitutional right not to testify or answer questions related to the subject matter of this hearing.
Well, wouldn't you know, our Judge Napolitano said the brief time she was speaking, she might have landed herself in deep doo-doo. Explain, Judge.
Yes, she might have, Neil. Good afternoon, and thanks for having me on with you. Look, there's a couple ways to look at this. The Fifth Amendment has been interpreted by the courts. That's the amendment that says you don't have to testify against yourself as an all or nothing proposition. You either give no testimony other than saying who you are, or you answer all questions truthfully. If witnesses were permitted to pick and choose which question to answer, then they would control the forum rather than the questioner. So she either waived her Fifth Amendment right by making her statement, meaning she now has to answer everything, or she certainly waived her Fifth Amendment right about the statements she made. So when she said, I didn't do anything wrong, I didn't break any laws, I didn't violate any IRS procedures, she waived her Fifth Amendment right on those three categories. Anything wrong, federal laws, IRS procedures. And the House of Representatives can go around the corner to a federal judge, not far from where I am now, and get an order directing her to answer their questions on those three subject matters because she volunteered to say that before she invoked the Fifth Amendment protection.
So if Darrell Issa wants to bring her back to the House to talk more about this, he can. He could subpoena her, and she could either go through this again, or she could be questioned on these areas that she mentioned in her introductory remarks before she stopped
and then if she refuses to answer questions about the three statements you just ran her making, anything wrong, federal law, IRS regulations, Darrell Issa, the chairman of the committee, can get the House of Representatives to issue a subpoena and get that subpoena enforced by a federal judge in a federal courthouse around the corner from where she made these statements. She either got very bad legal advice, which told her she could make these statements, or she was more concerned with her image and was worried that by invoking the Fifth Amendment she would appear guilty. But by making those statements, she opened up the door to a fair round of questioning on at least those three topics: anything wrong, federal laws, IRS regulations. And Neil, that's all they want to ask her about, is those three areas.
I completely missed that. Judge, let me ask you, when someone pleads the fifth, obviously they take the risk of looking like they're hiding something, but there's a legal reason for it and to it. What is it?
In her case, the legal reason is she doesn't know where this is going to go. She doesn't know if there will be civil litigation against the IRS and she will be called as a witness. She doesn't know if somebody in the IRS will be indicted and she'll be called as a witness. So by not saying something under oath now, she is free to answer questions in the future without having to worry about how she answered them today. This is a privilege that we have under the Fifth Amendment, and her lawyers ought to have explained that to her. Had she not made those initial denials, she'd be home free.
Now, when you also plead the fifth, don't you help your cause if you want to be pardoned?
Well, if you plead the fifth and successfully plead it, that is, you don't make any statements, and then ask for a pardon, if you've been charged with a crime, there's no record of any statement you've made. The House of Representatives can't grant a pardon, but it can grant immunity from prosecution.
But I was thinking
it
for
can
the president,
basically
that
say,
it could be the president to say, just, she's been through too much, pardon her.
Only the president can pardon.
Gotcha.
But the House could say, whatever you say to us in answer to our questions can't be used in any prosecution against you. She'd have no choice but to answer. They've not gotten to that point yet.
Thank you, my friend, very, very much. Judge Napolitano.
New details are coming out about the administration's seizure of personal email and phone records from Fox News employees. Here's how the White House responded to the controversy.
You asked, again, about a specific matter, and I can't comment on the specifics of any ongoing criminal matter. But if you're asking me whether the president believes that journalists should be prosecuted for doing their jobs, the answer is no.
Okay. But does the Obama administration's track record prove otherwise? Joining us right now from Washington to weigh in is Fox News senior judicial analyst, Judge Andrew Napolitano. Judge Jay Carney says the president loves the press, and yet he's cracking down on them.
Isn't that strange that the president's people dispatched FBI agents who, in an affidavit to a federal judge, told the federal judge that James Rosen committed a criminal conspiracy because he asked a contractor who worked for the State Department to give him some information, knowing that reporters are permitted to ask any question they want, and knowing that if reporters receive classified information, the crime is the person who gave it to them. The crime is not that of the receiver.
Right, exactly. James Rosen was doing his job, and yet, you know, an FBI agent and a U.S. attorney in Washington, D.C., essentially in this affidavit called James Rosen a potential crook and a flight risk, and tricked a judge into signing it so that he could be surveilled.
You know, there's three parties here who really dropped the ball. The FBI agent who signed the search warrant, the federal prosecutor, the U.S. attorney for the District of Columbia, who directly or through an assistant approved the application for the search warrant, and the federal judge who bought this nonsense that when a reporter asks a government official or a person possessing secrets to share something with him, somehow that's a crime. Steve, the Supreme Court has ruled clearly, unambiguously, and without exception, if a reporter acquires secrets and they are matters that the public wants to know about, it is not a crime to ask for them, to possess them, to retain them, or to publish them. It is inconceivable that James committed a crime, and the FBI ought to have known it, and the U.S. attorney ought to have known the law, and the federal judge who signed the search warrant should have rejected the search warrant based upon that rubbish.
Yeah, it's not just a little egg on some faces, it's a whole omelet. Judge Napolitano joining us from D.C., thank you very much.
Pleasure, Steve.
Of course, President Obama has said that he learned about this targeting of conservative groups through news reports, and so clearly you see the Speaker of the House does not believe that the president was insulated, that this was going on. Greg?
Mike Emanuel on Capitol Hill. Mike, thanks very much. Well, let's take it to the judge. Fox News senior judicial analyst Judge Andrew Napolitano is here. Okay, I may be the lawyer, but you're the judge. I defer to you. I read the cases, the two Supreme Court cases, Rogers and Brown, and I think they stand for the proposition that what she did is perfectly okay because you can only waive your right in a trial or a grand jury proceeding.
Well, you know, the law is a little ambiguous. One of the reasons it's ambiguous is because what Ms. Lerner did yesterday so infrequently happens. The typical invocation of the right to remain silent, the person invokes it for every single question except, who are you? And eventually the questioner, the member of the committee, the chairman of the committee, concludes that they're going to keep doing this. Why should we waste everybody's time? What she did yesterday is very unusual. Now, she is a lawyer, and she's advised by counsel,
right,
and her statement was written, so this was not anything inadvertent.
It's very deliberate.
She obviously deliberately yesterday set out to make a statement.
Right.
I didn't do anything wrong. I didn't break any laws.
She's got a First Amendment right to declare her innocent.
I didn't violate any IRS proceedings,
right,
but I'm not going to answer any more questions. So there's two ways the courts will look at this. One is the Greg Jarrett way, which is that the right to remain silent and the right not to incriminate yourself is so fundamental and yet so misunderstood that it can only be waived with a knowing, intentional waiver where someone articulates that, yes, I understand that I'm waiving that right. It can't be waived inadvertently. The other line of cases is you can't have it both ways. You can't pick and choose which questions to ask and which to answer, and you can't both make a statement and then refuse to answer questions about the statement.
Right.
So I am sure that Congressman Issa's lawyers will look at the second line of cases, the one that support the position of their client, Congressman Issa, because he wants to bring her back.
Unless they just want to badge her.
Well,
but hold your thought there. We're going to take a break. I'm going to hold you over because we have lots more to talk about in this case, including the fact that that was just kind of a broad declaration of innocence. She wasn't specifically addressing the main prevalent issues in the case, but we'll talk about it with Judge Andrew Napolitano in just a moment. Stick around. Lots more on Studio B. In front of Congress, Lois Lerner of the IRS yesterday invoked the Fifth, saying, I haven't done anything wrong. I haven't provided false testimony. I haven't broken any laws. Back with Judge Andrew Napolitano. All right, now that's not talking about the issues specifically in which she might subject herself to cross-examination. So she didn't waive her Fifth on that basis, did she? And what happens to her next?
Well, if Congressman Issa wants her back and calls her back and she shows up and doesn't answer, I think they'll be unforgiving because I think they'll think she tried to pull a fast one on them by both proclaiming innocence and refusing to answer.
Right.
They will take her around the corner to a United States District Court judge, and a judge will decide, was this substantive testimony subject to questioning, and did she waive the Fifth, or can she still assert the Fifth? And a judge will decide. If the judge tells her to speak and she doesn't speak, she's going to jail.
Really?
Yes, she'll go to jail until they decide that jail is no longer going to coerce her into speaking.
She would have been better off to stand 5 minutes before the hearing on the Capitol steps and say I didn't do anything wrong.
Correct. And
then go in and invoke the Fifth.
Correct.
Right? That would have been the smart move.
I think she took her own counsel.
Always a bad lawyer when you represent yourself.
There
Judge,
you go.
thanks very much.
Pleasure,
Judge Andrew
Greg.
Napolitano.